Ms. Hardy, we've been having a little discussion about the way forward, and our provisional view is that you may wish to have an opportunity to make some submissions on the documents that have just been handed up, like the position in front of the FTT, in which case we would invite written submissions on that. And then after you have received the judgments in draft, it won't surprise you to learn that we will reserve our judgments, you can have a further opportunity to make written submissions if necessary on the disposal of the appeal.
I'm grateful for that indication. On the documents that were handed up, I am not sure it's a complete suite of all the relevant documents. So
I follow. I mean, it's whatever anybody's been able to do in the last hour. And it may be that there are further documents that one or other of you thinks that we ought to see, but I don't want to shut you out.
No.
Nor do I wish to make your submissions on the hoof, so to speak. So I think you each need a fair opportunity to make submissions on the position in front of the FTT. I would hope between you can agree a timetable for that, a relatively short one, I might add, and then we will reserve judgment. And as I've said, when you get the draft, you can make further submissions in writing on the proper disposal of the appeal.
If I may, would your lordships be attracted by 7 and 14 days, or would you like it swifter than that?
I think 7 and 14 days is probably acceptable.
Yes.
Yes.
I'm grateful.
Yes. Thank you, my lord.
Thank you. Yes, Ms. Poots.
Good afternoon, my lords. I just have a few short points in reply on condition A, although of course I'm happy to go into detail on any of our arguments if it would assist at any point. The first point is my learned friend took you to the First Tier Tribunal at 153, which is on page 227 of the core bundle. And this is where the First Tier Tribunal records the effect of insufficient profits on priority distributions.
Yeah.
And I accept that recording of the effect of those insufficient profits is incomplete, in that if priority distributions are greater than profits, then there is a limit on the actual profit distributions under 10.3. But the difference is then made up in terms of payments rather than profits by clause 11.5, which my learned friend showed you. Now, that then is recorded in 153 as one of the points the First Tier Tribunal took into account, but of course it was just one part of the First Tier Tribunal's extensive analysis on condition A, and not, wouldn't say make any difference to the conclusion on condition A. But in any point, it was not a point that was relied upon by the Upper Tribunal. So the Upper Tribunal's conclusions on condition A are set out very clearly. I don't think we need to go back to them, but they deal with both limbs and C, both limbs B and C at paragraphs 153 to 156, which is on page 158 of the core bundle. My learned friend made a point about the tribunals having used from time to time the phrase profits and losses rather than profits or losses when they're talking about the real application and so on. I confess I'm struggling to understand the significance of that use of the language in just recording submissions and arguments, but in any event, it is clear that in this case both tribunals understood that the cap could apply both if there were insufficient profits and if there were losses. So either situation could be relevant to the cap. Just to give an example of that, the Upper Tribunal at 151 used that phrase, insufficiency of profits. So they clearly have both possibilities in mind, but both of those possibilities were possibilities that it was not reasonable to expect. They were merely possibilities or risks, not one that anyone was expecting. There's just one small point in this context on the LLP agreement that I don't think your lordships have been shown, which is just the LLP agreement and how it deals with losses. This is in the supplementary bundle at page 40. The clause right at the top, clause 10.4, deals with losses. And we see that those losses are allocated to one of the corporates.
Yeah.
And not visited on the individual members. So the impact of losses is the same as on individual members is the same as the impact of insufficiency of profits in this case, in that it is one of the factors that decides whether the cap applies, as it were. But it's nothing more than that. I'll turn next to the possibility of losses that my learned friend has raised. And there's just one factual point that I think it's important to note, and we can do it by reference to the first tier. If we go to page 209. No, I think I could.
209?
209, yes. And it's paragraphs 110 to 112. And the point I just want to make clear is there is a difference between the fund, which is a different entity, and this LLP, which is one of the sub-investment managers. So the losses that, not the losses, the risks and possibilities of risks that are present in the fund are not necessarily the same as those that are present for the appellant as sub-investment manager. And we can see that the first tiers recognise that. So 110, they talk about risks and things that actually happen to the fund. And then at 112, they talk about, as well as the risks for the fund, they recognise that there are possible risks for the appellant. They're not the same risks. But in any event, the highest that any of those things can put is that they were risks, not things that it was reasonable to expect. And my learned friend rightly accepted, I think, that at the beginning of each year, there's no finding of fact that at the beginning of each year one did the board or the partnership thought about his risks and decided that it was reasonable to expect a loss or an insufficiency of profits in any given year.
So you say, do you, that the reasonably expected test is not simply an objective test. It actually requires the taxpayer to consider whether those risks will or might eventuate, and if so, that consideration must be reasonable.
Yes, exactly. Exactly.
Yeah. I mean, in other parts of the law, for instance, whether some species of damage is reasonably foreseeable, you don't have to show that the person in question actually considered the question. It's a purely objective question.
I see that, although that's difficult to envisage in these circumstances, where the only way that one could have any expectation about the profits and losses is by being on the inside. So by knowing the business plans and the forecasts and so on. I'll just check whether the wording of the provision gives us anything additional on that, but I don't think it does. But yes, it's difficult to see how one could have any expectation about profits and losses. But if one did want to look at it entirely objectively, then a business such as this is hardly going to run year from year in the expectation of making bad profits or losses. So one reaches the same conclusion. Yeah. Then the final point I wanted to cover was just the point on sleeping partners that my Lord Justice Lewison, you asked my leader about this yesterday in the context of Condition C, and of course it's entirely possible that a sleeping partner would fail Condition C and get out of the legislation on that basis. There's just one extra point to note, which is that a true sleeping partner would also fail Condition A, It might be helpful to have that legislation in front of you so I can make that point. It's in the authorities bundle at 43. And we can see in subsection 2 that relevant arrangements means arrangements under which...
Sorry, I'm behind you. Where am I supposed to be looking?
I'm so sorry. Page 43 in the authorities bundle.
Yes.
So subsection 2, relevant arrangements means arrangements under which amounts are to be or may be payable by the limited liability partnership. Then these are the key words in respect of M's performance of services for the partnership. And we see that reflected in step 2 in the opening wording as well, that those words in respect of performance come in there as well. So there would a true sleeping partner would also fail condition A, or would always fail condition A. It may also fail condition B. And unless there's anything further, my lords, I think that is all I have in reply on condition A.
Thank you very much.
Thank you.
Yes, Mr. Bullock.
I will be, I hope, very quick, subject to any questions with which I can help the court. So the first point is about the history of the appellant, of the respondent LLP in the broadest sense. My learned friend started with this, referring to the statement of agreed facts and the evidence of Mrs. Kerridge and Ms. Kerridge. It's true that there have been various BlueCrest LPs and LLPs. Paragraph 12 in the statements of facts, which is at the beginning of the supplementary bundle, deals with the genesis of this LLP. This is page 5 of the supplementary bundle, paragraph 12, under the heading of the appellant.
Yeah.
Paragraph 13, commenced business in 2010, providing investment management services and so on. And in paragraph 14, when in June 2014, one of the other LLPs transferred its business and assets to a limited partnership, the business of the appellant remained unchanged. This isn't a major point, but this was a freestanding LLP carrying on its business. It wasn't the transferee of an existing business. And I don't think there was a finding of fact or anything in the statement of agreed facts or anything in the Mrs. Kerridge's witness statement to suggest otherwise, or to suggest that everyone who is a partner in the BlueCrest LLP that we're interested in had been transferred in or had previously been a partner in a previous LLP or anything.
Does it matter?
I don't think it matters, no, but just I want the court to understand what the proper factual
Yes, I
position
just wanted to follow that up because we were being confidently told that this was all done just as a matter of machinery, really, and nothing else, with no kind of tax planning in mind. That may or may not be relevant for me. Well, of course, I don't doubt anyone's good faith in telling us what we were told.
No. I mean, there's no question of doubting good faith, but there are only some facts found by the tribunal.
Well, that was my impression. We don't need any findings of fact on that point, and there aren't any.
No, precisely so. Just very quickly, there was some talk about 11% of the partnership's workforce being partners. Again, I think that needs to be seen in context. I think the 11% figure comes from taking 40 partners who failed condition B on the tribunal's construction out of a total of 366 workers, employees and partners grouped together. So I think that's where you get the 11% from. It's not 11% of the partners or anything of that nature. I think on a similar approach, if we had on our primary argument, there'd only be 4 partners with with significant influence, so you'd have a figure of 1%. But again, it's a so what. I mean, no one's saying that there's a threshold that you can't possibly have only 10% of people having significant influence or only 1%. I'm not saying it's rigidly defined, but just so the tribunal is clear, about what the 11% figure is. We would say perhaps more striking is that on the Upper Tribunal and FTT approach, about half the members of the LLP are said to have significant influence, which we say is a strikingly high number.
The only 4 on your basis, or the 4 original EXCO?
4 original EXCO.
Yep.
I'll come back to expanded EXCO very briefly, just to flag the tribunal's findings on that. Well, I can do that now. That's in the FTT decision at 201, which is in the core bundle. Sorry, I forgot to write down the page reference. So 236. I'm grateful. 236 in the core bundle should be paragraph 201 of the at the bottom.
Oh yes.
I don't think I need to read it out, but if the court just wishes to cast an eye over 201 to 203,
And is it right that the revenue have always accepted that they're not called?
they've always accepted that original EXCO
Yes,
had significant influence.
had significant influence. So they were not they were never assessed. They weren't appellants. Is that right?
I think on assessment, I'm not 100% sure.
Anyway, by the time we got to the FTT, there was no
Yes.
dispute about them.
Yes.
Yeah.
In the litigation, there's never been any doubt. But equally, the revenues always been clear that the expanded, the additional EXCO
Yeah.
people didn't benefit from that same treatment. But that's I'm just flagging that for the tribunal's note, really. Just to add to that, there's no separate appeal against that finding, although it might be swept up in the contingent cross appeal to some extent. Your Lordships also asked about the portfolio manager's terms and conditions. Those are summarised in the FTT as 81 to 112. We don't have in these bundles job descriptions or formal papers setting out their role. In fact, I don't think we had those before the FTT. The majority of the evidence, apart from the oral evidence, came from something called the facts paper, which there's reference to, but we don't have in the bundle. Again, we could obviously provide it, but for our part, we'd be content for the court to work from, to the extent necessary, the description in the FTT decision at 81 to 112.
Thank you.
Then, this is following up something I'd said about the importance of market rates for various roles within the FTT. I think it was page 102 of yesterday's transcript, if that matters, but it's the evidence and discussion at FTT 69 to 71 in the core bundle at 203. Again, and that's just a note. I was broadly accurate in my summary, but if the court wants to be entirely accurate, then that is the reference. I know the friend said this morning that there was evidence of the board consulting portfolio managers, and she said that could amount to significant influence. I just want to flag that there was no finding to that effect. Similarly, on this business of the FCA C4 function accreditation, if that's the right word, that was mentioned, that's recorded in the FTT decision as a submission being made. It's set out in the evidence of Mrs. Kerridge. It wasn't challenged in cross-examination. But again, what's missing is a finding that that gave rise to significant influence. I'm sorry, I'm hopping about a bit, but I just want to cover everything reasonably quickly. I need to be clear about our objection to finding, minding and grinding. it's not that the tribunal judge brought his own experience to bear on the question. That's obviously part of his role. Well, the problem with it is the use that he made of it, and the we would say the fact that he focused on the day-to-day job, as it were, of the partners, rather than on their management function. So the finding, binding, and grinding was a way of describing something an employee might have done, rather than a way of describing what sets a partner apart from an employee. I mean, it ties in with every other aspect of our submission. But just to be clear, I'm not criticising the judge for drawing on his own experience. There was a discussion, and this is obviously a central issue, about the type of influence and the extent to which using words impact rather than influence, etc., etc. This isn't, we're not meaning to be purely semantic about it. When I've used words like impact, it's to differentiate different types of effect that a person might have on a business. Some of them are accidental. The IT person who fails to debug the relevant software so that there's a crash, etc., etc. That is undoubtedly an effect. That could be described as an influence, but it's an accidental effect. It's not something that someone has sought to bring about. We're saying what we're looking for in the condition B test in full is influence over the affairs of the partnership derived from mutual rights and obligations. We've always said that. The question is just how closely linked the mutual rights and obligations have to be to the LLP agreement, and ancillary agreements. Our primary position was and remains that one can take a practical view and see how the agreements are operated in practice. That's the way we'd put it below. Our secondary position in response to the judicial questioning is that it's stricter than that, and unless one can identify specific mutual rights and obligations, then there's nowhere the influence isn't properly grounded in the way required by the statute. But we've always been looking at the same type of influence. We've always been looking at the high-level influence, an opportunity to direct or try to direct the affairs of the partnership at the high level in accordance with one's will. So it's a deliberate directing as opposed to an accidental effect on, or at least that's one dichotomy that one might consider in relation to influence. Sorry, just to be clear about that's in answer to the suggestion that I was being overly semantic in differentiating influence and impact. I was using different words to try to differentiate between different types of effects, as I say, that a person might have. Just quickly on the procedural side, if I may, appreciating that the bulk of this will now be dealt with in submissions in the way that the court has indicated shortly after the short adjournment, immediately after the short adjournment. One point, a point of agreement between the parties, with reference to paragraph 75 of our skeleton, my own friend said this morning, and I think it's page 52 in the transcript, that we were wrong, or would be wrong, to criticise the judge for failing to make a finding on significant influence of the sort that we were arguing for, because, she said, the judge had already decided that that was the wrong type of significant influence. Well, be that as it may, it appears from that it is common ground that there was no express finding. So in our paragraph 75, we would say that does confirm that it would be open to the tribunal to make the quick disposal on the basis that there was no finding of significant influence of the requisite sort. I am not going to spend long on that because I appreciate that the court hasn't got to that point yet. We've been through the point about the secondary position. I think there are some points I should make at this stage, just to be clear, and because my own friends will be making submissions on this, it would help probably for me to outline our position on the pleadings. First, as my Lord Justice Arnold has pointed out, the decision application refers to the mutual rights and obligations, and that's at least a very similar point to the point that we've been discussing, and possibly the same point, but it's at least very similar. I think this is now common ground, even to the extent that HMRC made a concession below. That can't bind the court's approach to the proper construction of the statute. It might affect the disposal, but the parties can't agree between themselves that the law is X and expect the Court of Appeal to say, oh, well, that's right, we're not going to ask ourselves the proper question. No, the court is obviously going to reach a conclusion on the law, and if the parties have proceeded on the wrong basis, well, that's a matter that has to be taken into account, but it doesn't affect the court's legal conclusions. Now, it is said that if the revenue had made its secondary position its primary position below, I think that's effectively what's being said, then there would have been, the evidence would have been presented differently. We say that is a frankly surprising submission in the abstract. It was part of BlueCrest's case that how the LLP was operated, what the LLP agreement was, what it meant, was part of BlueCrest's case before the First Tier Tribunal. The evidence was that the LLP operated within the terms of the agreement, and that even if decisions were taken informally, they were, to the extent necessary, ratified. We would say, and these are the paragraphs we've looked at, paragraphs 108 and 189 of the FTT decision in the core bundle at 209 and 233 respectively. We would say, on the face of it, there was no room for a separate argument, a new argument, that in fact that was the written LLP agreement was not the LLP agreement at all. This isn't the sort of, it's not that the revenues argument would open up a new line of inquiry, a new field of inquiry. BlueCrest would have to change its case on what its LLP agreement was. And I just don't understand how BlueCrest can properly do that.
No, it's not changing their case on the LLP agreement. I don't understand there to be any dispute that the agreement was the written agreement. The suggestion, I think, is more along the lines of we would have looked for alternative sources of mutual rights and duties. We would have put evidence before the court as to alternative sources of mutual rights and duties. So hypothetically, they might have tried to prove a collateral oral agreement.
Oh, well, sorry, when I say the LLP agreement, I meant that was the totality of the agreement that governed the operation of the LLP. There was evidence as to how the LLP was operated, and that was an important factor before the FTT. It's not clear to me how that would properly change simply because a different legal question is asked in light of a different approach to condition B.
And especially as the LLP agreement contains a whole agreement clause.
And particularly in light of factors of those sorts. We'll come back to it. The position is more complicated when one looks at the pleadings. And I think, in fact, BlueCrest was arguing for various implied terms, and the revenues position or concession isn't one that's set out in the skeletons, or still less the statements of case, but I'm reserving my position on that because we need to go through it properly, but it was one that's evolved. So we will be making a submission later that any concession, if that's the right word for it, was only made after the BlueCrest had formulated its evidential case. But as I say, I'm flagging at this point that it's one thing to say, this argument that you're making would have required us to look at not what the red car was doing, but what the blue car was doing. as it were. We're saying this argument, the focus remains on the red car, and the BlueCrest had to describe what the red car was doing in any event. So there hasn't been that radical a change. It hasn't changed the focus of the inquiry. It's changed the legal question that you ask of the LLP agreement, but it hasn't changed the focus. So I'm just flagging that now because I think that's fair to BlueCrest. I don't think I need to say anything further on disposal. Obviously, I've already said that it remains open in our submission to the court to find that we're right.
Well, as I've said, you can
yes.
make submissions on disposal once you've got the draft judgment.
Yes. So, subject to further questions, I think that is all we need to say in reply.
Thank you very much, Mr. Villac. Well, as prefigured, we will reserve our judgment. You will get a draft in the usual way. Comes subject to a strict embargo, which means what it says. It will be your opportunity to correct our English, but not our reasoning. And in the light of the draft, you can make submissions on the disposal of the appeal, unless for any reason you agree to dispose of the appeal. But if you don't, then please make submissions. Again, I would expect you to agree between you a relatively short time scale, and I suppose the winner ought to go first in that time scale and the loser second.
We will do that.
Right, thank you very much.